ఏందన్నది పెట్టేది తిరిగితే
ఆడలేదు.
Phone call?
Dilip.
Hi there, Ashok.
Hey John, give me 1 minute, John, okay?
Yeah. All right, sounds good.
చెప్పండి అన్న.
నేను co-host చేస్తున్నాను. ఒకసారి అందరిని అడ్మిట్ చేయవా?
Okay, సరే.
John, let me try to see settings, if there are any settings for you to join from Germany, okay? Give me 1 minute, okay?
Sounds good.
John, you want to try again?
All right, one sec. It's the same error code.
You want to log out and log back in? Or
Yeah, same error.
okay.
I can just talk to everybody through the phone.
Okay.
If that works.
Okay, give me 1 minute. Okay.
Mm-hmm.
Okay.
ఇంకేమో సోఫాలు అరగా అన్న కూటుపురం నీవా.
Excuse me. I request everyone to mute yourself, please. So the people who joined is we shared only the Zoom link with the handful of people. So I request everyone to mute yourself, please. So good morning. I just reached Hyderabad. Good morning. And John, our attorney, today is from, actually he's in Germany celebrating Oktoberfest. John, thank you for joining at 3 a.m. And we also have people from Dubai. We have people across the globe. And this is also being live streamed. And before we start, can I request everyone to observe 1 minute of silence for our TANA immigration chair, Sudhakar, who lost with cardiac arrest. So I request everyone to observe 1 minute of silence, and so that his family get enough strength. And we also lost, it's more than an individual, we lost a great soul who has been great in philanthropy, who is always there for all the non-profit organizations. So I request everyone to maintain a 1 minute of observance, please. Okay, thank you. So going to our topic, I would really like to thank Jay Garu for giving an opportunity for introducing John um, and um, and making this event. This is one of the burning topic right now we are facing in the community or everywhere. Like many students, many employees are going to Nepal, Malaysia, different parts of the world for getting a visa slots. And once after reaching there, they're facing a problem with 221G and the time period is unknown. So let me give an introduction about John. Probably most of you must have heard about him. John Watson is a litigation attorney with several major wins against the US immigration agencies in the federal court. He is the one who actually changed the face of the H1 adjudications within USCIS, making the process much easier and less expensive. He also he was also responsible actually during our last election campaign. One of the main agenda we took was to include H4 EADs into automatic extension. So he was responsible for L2 EAD instance to status and also the H4 EAD auto extensions. Mainly he focuses on making immigration easier for an Indian IT community, and he's also an active member in IT. So thank you, John, for your time. And before you start, I request Niranjan Garu to say 1 minute of words, please.
Yep. Thank you, Ashok. Thank you, John, for accepting our invitation, and thank you for all the joinees, and thank you, ABN viewers, for watching this online. And this is a 221G is a need of our program. Like John, you might know, lot of Indians, especially Telugu people, they use H1Bs, the quota more used by the Telugu community people, and as well as this 221G is like is really causing the issues for all employers and students, and as well as the visitors visa people, and it is impacting everybody's schedule. So thank you again, once again, for taking this step and helping the Telugu community people, so that a lot of people joined on this call. So they might have a lot of questions how to resolve the 221G. Probably they are receiving this 221G documents from consulates recently. That too, what I am hearing for last 2-3 months, lot of people, whoever attending the visas, it can be H1B people or business people or visitor visa people, most of them are getting these issues. So like everybody, I have a question too, like how we can avoid this 221G by putting some addressing this issue at the larger level. So help the community. And thank you, Ashok, for taking this initiative. Thank you, and Murali, Anjay Chaudhary Garu, and the rest of the TANA leadership. So thank you, and back to you, Ashok.
Thank you, Niranjan Garu. So, Attorney John, it's all yours. And probably in the end, we'll open a questionnaire so that if anyone has questions, they can reach out to you, because we have been approached by the people. We have been approached by the people from Dubai, Australia, regarding like they went to visit their parents and they got the 221G. So, Attorney John, it's you.
Thank you very much. It's good to be with you all. I guess it's morning in India. It's middle of the night here in Germany. It's just as a quick reminder before we get started, because I'm on the phone, the sound is not as great as I would like. So if you can make sure that all of you are muted, and then unmute yourself when it comes to the question time. But what was spoken earlier is 100% true. The 221G issue has basically hit in epidemic proportions. And it's initially 221G was supposed to be used when the U.S. State Department had a legitimate concern about terrorism or national security. What we're seeing now is toddlers are getting 221Gs, and it makes absolutely no sense. From all we can discern is they've figured out that issuing 221G is just one way for them to avoid having to do any work, because they can put somebody in administrative processing 221G and let them sit there forever, and there's no internal time clock ticking against USCIS. And part of the strategy I want to talk to you about today is giving them, enforcing a timetable on them, so they have to make a decision. I sue the federal government in U.S. federal court. I used to work for the U.S. government. I used to defend them from the very types of cases that I now bring. So I come at this with a lot of experience on the government side and a lot of experience on the private practice side. And the first question I think I've ever received from just about every single person I've talked to, especially those from India, is, will the government retaliate against me on a later immigration filing if you join suit? I can tell you that the statistics are in on this. I mean, we've been suing thousands of lawsuits against the government immigration agencies over the last 4 years. And I can definitively say that the people that had sued in the past tended to get treated better than people who didn't sue. And a big part of that reason is litigation is incredibly time intensive for the government, and they try to avoid it when they can. So if you've already shown that you're somebody who's willing to sue, they tend to not mess with you as much because they don't want to be dragged back into court. I think when we sued on behalf of IT-Serve, I had a harder time getting the IT-Serve membership to go to court than I had having the judge and convincing the judge of the strength of our case. So I kind of have a sense of where y'all are coming from, and just wanted to hit that up front, that retaliation is not something I think you need to worry about. Now, there's a couple of scenarios that come up in 221G repeatedly. The first is end client letters and proof of a project. The other is sometimes the 221G notice will have nothing on it. There'll be no reason or explanation for it. The third one is the 5535, the entire international travel history. So these three different scenarios, and then there's a few other stray type issues come up, but those three issues predominate. So what we're looking at in the H-1B experience or employer letters and proof of project is suing them under what's called an unreasonable delay or a mandamus case. And the argument is that we have already litigated, the government has settled with us on this issue, and they've updated your policy memo to say that end client letters and proof of a project is irrelevant to the adjudication of the H-1B visa. Right now, if you apply for an H-1B visa petition with USCIS, they won't even ask you for end client statements and proof of project. And in my opinion, you shouldn't be giving that to them in the petition process if you can avoid it. So the question of law that is central to the case has already been decided. But the issue then for the court becomes, if USCIS has determined that this is irrelevant to the visa adjudication and they're the lead agency in this case, then the State Department, by delaying your visa adjudications for an irrelevant requirement is unreasonably delaying your case. So, stated another way, because end client letters and proof of a project is irrelevant, any time spent is wasted while they're demanding these irrelevant documents. And I think that's something that the court will be incredibly sympathetic to. And more importantly, when you sue the government, their decision-making process starts with, will we look bad in court? And this is one of those situations where they don't really have a defensible position, in my opinion. And they will recognize up front that they'll look bad in court. We've been lobbying the State Department on this issue for 5 months now, I think. And we've gone back and forth with them, and they're hemming and hawing over the issue, but no decision. So what we want to do is, when we file this case, we will give them a timeline. And that timeline is set by the federal rules of civil procedure in federal court. And within 60 days of us filing the case, they are required to answer our complaint, which basically means they're going to decide whether or not they're going to settle the case or they're going to defend the case. In that 60-day window is when we see the vast majority of the agency reversals on themselves to avoid litigation. And oftentimes they will just, start approving left and right just to avoid any issues. So the strategy, I think, for the 221Gs is solid for the H-1B and client letters. I think that one is, I can't say as a lawyer anything is 100% chance, but it's very solid. And I think it's going to be a winner in court. And because it's going to be a winner in court, they'll probably settle, is my opinion, on this issue, and they won't defend the case, which would mean the policy goes away that regarding end client letters within the State Department. And people who are stuck will hopefully be granted their visas after this is all wrapped up. The other scenario where they don't provide any details on the 221G form, that is a violation of what's called the Administrative Procedure Act. The Administrative Procedure Act dictates, it's the rule book for the government, how the federal government's required to act. And one of the things is that the agency is required by law, and the courts will enforce this, to follow their own regulations. And the State Department has a regulation that very explicitly states, if they're going to place you in 221G, they're required to give you a list of reasons and things that you can provide to overcome that. So by not providing you any explanation, they violated the law. And I think that's a very clear-cut issue that's not terribly controversial. And because it's a pretty clear-cut issue, it's easy for a judge to understand without having to really get into the nuances of immigration law. I think the agency itself, the Department of State, will recognize very quickly that they're in a bad position. So both of those cases are, I think, high probability winners. And because they're high probability winners, again, the government tends to settle cases that they think are surefire losers. The third one is a little bit more of a battle, and that deals with the 5535s. And that really is going to depend, that the way we argue those cases will really depend on the individual facts of your case. You know, for instance, if they're requiring a 5535 for, you know, a minor child, that would present us with a different set of arguments. Sorry, can you mute yourself? And then, so the 5535s are very labor intensive and focus on the individual more than the others. The others have a very common legal question, which lends them to being filed together in a group. And when we file in a group together, we can have a lot more options in terms of where a case is filed. And where the case is filed makes a good amount of difference, because different areas of the country have what are called circuits for the judges. And the judges in these different circuits have different interpretations of the law on unreasonable delay. And so the law on the West Coast of the United States, California, Washington, that area, Washington State rather, those courts tend to view the law of unreasonable delay in a way that is more favorable to us than the government in this particular scenario. So one option we're looking at is a group case where we file on the West Coast. The other option is doing a whole bunch of individual cases for people and just drowning the government in litigation. So that's a strategy that, you know, as a client, you get to choose which of those you want to go for. And, you know, if you're interested in going forward with the litigation, we can set up a time to speak individually to address any of your questions that you've got. But right now, if there's any questions that Ashok, that comes immediately to mind, go ahead and ask me that. If not, we'll open it up to people's individual questions.
So thank you, attorney. So the first question I have in my mind is there any other alternative for the people who got their 221G? I mean, we know we can't expedite it, but is there any alternative? Because the people are stuck back home in India, they are stuck in, like, you know, several parts of the world. So do you have any recommendation or any alternatives you think of?
So unfortunately, most of the clients that come to us for litigation, they've already exhausted every conceivable option. And in this situation, we've seen people try to use congressional inquiries to have their congressman or senator, you know, put pressure on the agency, and none of that has worked. The agency doesn't have any internal timelines or requirements regarding 221G. When we've seen it, they've let people sit in 221G until the visa times out. And, you know, on an H-1B or an L, you're looking at either 2 or 3 years, typically. And that's how long they're willing to wait. And it's unfortunate. And I think it's a huge problem. And it becomes very evident and clear that it's just a way for them to avoid having to do work. And I don't think that's something that's going to be too sympathetic to a court. But, you know, unfortunately, there's just really nothing you can do once you're in 221G outside of filing a lawsuit against them.
Okay. Is it true, like I was told, is it true, like, if someone gets a 221G, can they go back and apply to the same class of visa with a different employer and go for an interview? I mean, no, I'm just trying to understand, I know, like, whatever you explained, so it's our long-term process, like, yeah.
So in theory, yes.
Okay.
But what we've seen is that the individual consulates, when they look at your file, they'll see that there is another one out there, another 221G out there. And they're saying, but clear that one up first, talk with that other consulate, and then get back to us.
Okay.
And so although in theory it's doable, in practice, the State Department has been not following that.
Okay. So I know, like, we spoke about going to the court and everything, right? So what do you really expect from us in terms of the people who are stranded, not from the organization, but really from the people, from the employees?
So for the employees that are stranded, the two things that I would say is, one, talk to your employer and see if they will contribute to legal fees. And then once we sign people up as clients and we get everything ready, the government has a 60-day clock in which they have to make a decision about whether or not they're going to defend the case. And in that window is when we see a lot of movement in cases like this, and they make a lot of changes, either policy-wise, or they just adjudicate the petitions to avoid litigation. So like I mentioned earlier, that there's a big difference between the 5535s and the end client letter versus blank 221G forms. So the pricing for those two is different, and the 5535s are a little bit more expensive because of the extra labor that goes into them. But for the other run-of-the-mill cases, so to speak, the cost per plaintiff is a $6,000 legal fee, and for the 5535s, it's $7,000.
Okay. But my question is, like, to fight in the court. So are you going to charge anything, or how are we going to do that?
Yeah, so we have to collect fees to fund the operation. So the employee can pay, or the employer can pay, or both can contribute to the cost of litigation.
Okay. So that's all from me, but can we open the floor so that, like, one by one can ask their questions? I know in this call there are people like who have been stranded for little over a year. There are some people who are there for 6 months, so yeah.
So those very lengthy delays, when you sue on those, and if you have them as a lead plaintiff in a group case,
Okay.
that's going to get a lot of attention. Like when they'll just look at how long the wait is, and what the court will do is they'll say, okay, if this person's been waiting over a year, and there's another person who's only been waiting a month, they're likely going to have to expect a year-long wait as well. And so those really long cases kind of make it the case overall stronger for everybody. Even if you have a lesser time period that's waiting that doesn't seem as bad or as egregious, the fact that we can show that there's an expected turnaround time of over a year makes it very persuasive on our side.
Okay. So I request everyone who wants to ask a question or who needs to give a suggestion to raise your hand so that we can go and unmute each one at a time. Srinivas Kataru, please.
Thank you, Ashok, to giving me an opportunity to raise my question. Mr. Attorney, what was the chances in case if the counselor has been collected the passports during the interview, but still they kept the person into 21G? This is my case. I appeared my visa interview on 2nd August. So during the interview, she was asking me, because in 2019, my L1 got denied. L1 visa, which is applied through Accenture. So she asked this question, why your L1 visa got denied? I said, I don't know really. The counselor has never disclosed the reason why it was denied. And she said, okay. And then she gave me the 221G, that LO slip, and then she collected all my passports, like all my passports in a sense, my family passports, including my passport and my wife and my kids' passports. And then I think after 1.5 months later, they sent 3 passports, like my wife and kids' passports has been sent, asking for the to provide the primary applicant's visa copy for a stamping. And they still kept my passport with them. It's been almost 50+ days.
Mm-hmm. So definitely your case is something that can be taken to court. And what makes your case especially egregious is they're holding your passport hostage and you're unable to travel as a result. So that once they take your passport and they put that inconvenience on you of not being able to travel and move around freely, that, in my opinion, makes them have to move quicker than they would on a regular case because of the burden that they're placing on you. Under the law, the Administrative Procedure Act, when it's talking about how long an agency should take making a decision, it says that they're supposed to take into consideration, with due regard, the necessity and convenience of the applicant.
Okay.
So as I'm looking at that, not being able to travel is a massive inconvenience and it's a massive stressor. And I think that's something they have to address faster than other cases.
Okay.
Thank you, Srinivas. Someone with the name Android Blue Dream, will you?
Yeah, this is Shanti. Hi team. Hi John. So in my case, I have attended a visa interview on February 3rd. So after that, my employer received some questionnaire about my experience and my skill set. They replied on time. So after that, my last case update was on March 3rd. So after that, I haven't received any update on my case, and I'm trying to reach this support India UStravels.com, and also I'm continuously calling to them for the helpline, but I'm receiving the standard reply, but that is saying that I need to wait. So I crossed 250 days. I don't know what to do, whom to contact. So what is my next steps?
Yeah, so that's incredibly frustrating
Yeah.
because they've got all the documents they had said they needed to adjudicate your visa, and they're not doing anything with it. And especially as long as your case has been going, that's one that I think is a very strong case, and it's hard for the government to explain what they're doing in that situation. And usually when it's hard for the government to explain their position, that's when you have the best case, to be honest. So for those of you, the onboarding and the interest questionnaire that we have for this is on a website, rnlawgroup.com/221G. And if you go to that website, you can provide your contact information, and you can we can get in touch with you from there. If for whatever reason you don't, that website's down, you can email me directly at John, Jon, at wbf-law.com. That's Jon at WB as in Bravo, F like Foxtrot, dash law, LAW.com.
Okay.
and we'll make sure that we give you all the information you need to make a decision.
Okay. So, John, I heard that I can go and book another slot and I can meet the consulate. Is it true? Can I go like that?
So, yeah, in theory, yes, that works. What we've been seeing in practice, however, is when you book that second appointment, they go and look at your history, see that there's an open 221G, and then they just say, you have to resolve that before we can decide on your current application. So although the possibility exists, the State Department seems to be closing that option down.
Okay. Yeah, other than this, any other options, John? Any other suggestions from your end, apart from this contacting other consulate or something, any other? Because I'm not getting any information, or this help support people is also not giving me any information. Just they are seeing the status and they are telling that status to me.
So John, so if someone is abroad, can they still file for the case in United States? I mean, can they be the defendants? Okay.
Yeah, they can be a plaintiff in the case.
Okay.
Where they're located at has an impact on where the case would be filed if they file individually.
Okay.
If they file in a group, there's a lot more flexibility in where they can file the case.
Okay.
But getting to your, was it Ashanti? Getting to your question, there's a lot of people in immigration law that are very smart and know how to work the system very effectively. And those people are stuck. They can't get help for their clients with the State Department, with 221G. Everybody just seems to be stuck. The State Department knows the problem, and they are thinking it over at the moment. But outside of a lawsuit, there's really, for this situation, there's really nothing that I can think of, or anybody else can think of, rather, that would be useful to try.
Okay, so correct me if I am receiving you correct or not. So I can able to reach that state government of the employer, like from where the employer filed my case, right? So I can able to reach to that particular state government, correct?
So you could sue where the employer is located at, or in the District of Columbia. Those would be the options.
So Saiti, I will send you John's email, and you can send an email to John. Okay.
Yeah. Okay. Because there are people, lot of. Yeah. Thank you.
Vishal, please.
Yeah, hi John. So good evening. So I have my question. So I have attended my visa interview on September 13th, and the visa interview checked all my documents and took my client letter and I-797 copy and everything. And they have asked questions to me, and I was able to answer. And after that, after some time, they have issued me 221G, and they have took all my documents first. They verified everything, and again they have given me back all the documents, and they have given me the passport back as well. So when I see my case status, it is showing as it is in administrative processing. So can I know like what will be the timeline for this? Because they have returned my passport, and a couple of my friends also who visited, who have attended the visa interview, for them they have issued 221G, but for them the consulate, the visa officer has taken the passport, and it has been given back by they have issued visa around like 2 weeks of timeline in 2 weeks, or like some people took like 1 month as well. So I just want to know, so what will be my timeline? Because After 6 years, I have traveled to India, and now I'm stuck with the visa issue over here. It's been a week only. I have attended the visa interview.
Yeah, that's very frustrating. So your question is there anything else that you can try? If in your situation, people are waiting for unpredictable amounts of time, and there's just no certainty in the process, and there's really nothing that we can offer except that if you sue the government, then their options narrow very quickly, and they're required to answer the complaint, which is them saying if they're going to defend the case or settle the case within 60 days. So the timeline is we would get the case filed in about 2 weeks. And then from that 2-week period, I would expect to see some resolution on or adjudication of the visa application within that 60-day window.
Okay, so while giving the documents, so visa officer told we will send you an email once we verify on our end, then you can drop your passport in any of the consulate. The visa officer has said to me.
Mm-hmm.
This is the conversation.
Yeah,
happened.
that's a pretty typical scenario for people that are stuck in 221G.
Rani Priya, please. Rani Priya.
Hey, yeah, this is Ranjit. Yeah. Hey, Tana, thanks for having this call, and thanks for the attorney as well. So, my question here is like, I went to a visa interview on Jan, and I was given 221G, asking for project details and employer-employee relationship. And since it was a new employer, which the H1 was picked up. And during the May, like the employer submitted the documents, but still they denied 221G, and then they sent the case back to USCIS asking to review and then approve or deny it. And then from there, it's still pending with USCIS, and I did not get any updates, or even employer didn't get any updates there.
Mm-hmm. So that's a frustrating situation because they're sending it back to USCIS, who has already agreed, and basically the court told them that the employer-employee relationship test that they use is illegal. So my strong suspicion is that USCIS will kick it around for a while and then send it back to them and say adjudicate. And once they do that, there's no timeline for them that they're required to act in to adjudicate the visa applications just at their whim. So the only way to really get certainty is once you start the lawsuit, they have that 60-day clock, and that will give you the best odds available of getting things done in a predictable timeline.
Okay, thank you.
Raghu?
Mm-hmm.
Raghu?
Hey, good evening, and thank you for giving this opportunity to talk. So, I had my interview in April. No, my Dropbox in April, and I had an interview in the month of May. And during the interview here, the officer asked me a couple of questions, a lot of questions, and I almost all answered every question. And finally, he gave me the 221G, the yellow slip, in Mumbai consulate, and asking me to submit all the documents from the petitioner. And I did approach my petitioner, and we provided all the documents, in which few documents we don't support from the full-time employee perspective, and I did written in an email that we don't support those documents. And from the May onwards, I did not get any response until now. And I did reach out to the support team, but no response. And they were saying to wait for 180 days time period. So how are we positive, like after 180 days we can get an update, or we can get like, you know, positive response from the consulate? Have you seen any of the cases before like this, John?
A lot. There's a large number of people, and that's why we're having the call, is that scenario is very common, unfortunately. And, you know, in terms of what happens after that 180-day clock, that 180-day time benchmark that they've given you isn't something that binds them. They're not required to do anything by that 180-day mark. That's just something they're telling people to get them to go away, basically. I think it was Ashanti earlier was saying, you know, she's been waiting 250 days. And so it's pretty evident that 180-day clock is irrelevant.
Okay. And you are saying to reach out to the State Department and stuff. Can you please elaborate on it? Like, how can we reach out to the State Department and stuff?
Well, all of the federal immigration agencies in the U.S., have really walled themselves off from any meaningful contact with the adjudicators in the government. So getting into the government has been very difficult. We've been successful in talking to the State Department about changing policy, but they are just considering it. Basically, our request is in 221G. But the reality is the only way to get their attention is to sue them. And once they're sued, they're forced to pay attention.
So, Attorney Thomas, should only the 221G, who got the 221G, should sue the USCIS, or anyone, the state government, or anyone can do that?
So are you asking if the visa applicant can sue, or if somebody else can sue on their behalf?
Yes.
Yeah. So the visa applicant would be the proper plaintiff,
Okay.
because they're the ones that, you know, unlike a visa petition, the visa application is individual to you. So in situations like that, if your employer is in a good location, we may want to ask them to join as a named plaintiff, just so we can make sure we have a good venue. You know, the options are for people that are stuck overseas that have a home and a residence here in the U.S., they should be able to sue where their home or residence is, if that's a good location. If they don't, if this is the first time initial H-1B, or, you know, they don't have a home or residence in the U.S., then, you know, location where we file becomes an issue, and that's where we'd probably want to put people in a group case to avoid being stuck in a court that we don't like.
Okay. Banu.
Yeah, hi, Banu here. Thank you. I have applied my H-1B through a private consultancy. In which in this year, February, I have got my 221G with a plain white slip. Nothing has been mentioned. No documents have been asked even to send a mail. So how can I come to know, you know, what kind of a query that they have? Because when I try to reach my employer, he stopped responding. I don't see any other info. He's a private consultancy. That is not the company where I'm working. So I couldn't get any details. I got struck from this February. So is there any way that I can get the information, what kind of a query that USCIS has in order to process my request?
So in theory, yes. in theory, you could file a Freedom of Information Act request and ask for any documents or information that the government has on you, and they're required to give that to you. There are some exceptions to FOIA, what they'll release and what they won't. But in theory, that would work. But if they've given you a 221G, and I think you said that there wasn't any document requests on that 221G, if that's the case, then they've violated their own rules. And when a federal government agency violates its own rules, that's a big problem for the courts, because the courts have them to put. So in your situation, I think that's a good case on Procedure Act that those, I think, should not be defended.
So attorney, on what basis do they get a white slip, pink slip, yellow slip, and a blue slip? Is there any, like, do they do any screening, or on what basis do they get that?
So as near as I can tell, it's random.
Okay.
And I say that because you look and see, there's toddlers who have gotten 221Gs. so there's no reason why a toddler is a security threat that, would have to provide this information. So I wish that there was some rhyme or reason to it, but it's just totally random from what I and other people that watch this can tell.
Okay. I have another question as well. So I have a valid B1, B2 visa. There is another consultancy mentioning, even though you have a 221G, we can file a petition for converting B1 to H1B. How valid is that?
So normally the change of status is done with a new petition. So if you're coming in, you can't work on your B visa. So if you're coming in, you'd have to get the new application or the new petition filed, and then adjudicate. The problem is the B visa is a no intent visa, which means that if you're going to enter the US on a B visa, you must not have the intent to permanently stay, which is different from an H visa where that prohibition has been waived under the law. So my only concern with that approach is that they could say that you lied about your intent, and that your intent was not consistent with the visa category that you entered the US in, the B visa, and that what you really intended was to stay permanently, and that they would mark that down as a fraud finding. That would be my concern in your situation.
Zamir?
Yeah, thank you.
Zamir?
Cool. Hey, sorry, can you hear me?
Yeah.
Hey, thank you so much for conducting this session. Really appreciate the time that you've been giving, John. I had a quick questions. So I went for a visa interview. I came to India after a period of 4 years. I've been in the US for almost 10 plus years. Came to India after 4 years, went for a visa interview. And during the visa interview, the counselor said my visa was approved for me and my dependent, and told me that we'll get the passports back in 7 days. So we came back, and to my surprise, I got an email like the day after that, saying that they wanted to do some additional verification and that my visa has been refused under 221G. And they asked me to fill in a DS5535 form with some personal details, nothing relating to the project or to the client or my job. And I've been stuck since June out here without any updates. So I had a couple of questions. I mean, I know probably it's a repeat, but is there any way to identify what exactly are they trying to find? Because there is no client or project request. It's only personal details and travel history for past 15 years that was required, that was requested in 5535. So that was one thing. And the second thing is and the second question, if I may ask really quick, is my visa extension is due in Jan. So My dependents got the visa stamp and they've returned back to US. It's only me who's the primary applicant who's pending for with an admin processing. And with me being in India and my dependents being in US, can I file for a visa extension? Those are my two questions.
Sure. So your first question is there any way you can find out the basis of the 221G? They're supposed to provide you with the basis when they give you a 221G, explain why they're requiring this information of you, so that you can focus your response on their concern. But with these 5535s, they're not doing that. They're just saying, give us this information, we need it. I think that's probably a violation of the regulation. It's a little bit of a gray area, but I would say that we have a good argument it's a violation of their own rules. So, but I wish I had something better to tell you, but unfortunately, the 5535s are being issued in a completely unpredictable manner. I don't know that there's anything that they're actually concerned about. They're just giving, like I said, they're giving toddlers 5535s. So clearly there's nothing that the toddler could, a 3-year-old could do to justify having to provide their 5535s. So I wish I had a better answer, but there's really no rhyme or reason to what they're doing.
Got it.
Hema Kanuru?
And so my follow-up question was, can we file? Sorry, Dana. So can I file for a visa extension while the primary applicant is out of US? Because my dependents, like my wife, she got her H4 stamp, and she's my dependent. She got her H4 stamp, and she returned back to the US as well. So now that my family is in US, I'm here. Is there any provision by which we can file for an H1 extension?
Yeah, you just file a new H1 petition. The employer files a new petition, and that should take care of it. That won't take care of the 220, but in terms of the extension, getting your H1 extended, the new petition should handle that.
But then in that case, my dependents won't be covered under the new petition, right? So they'll have to come back to India?
In theory, yeah, that would be the problem there.
Got it. Okay. Because my immigration team has been saying that they can file for an extension only after return back. And since I'm running against time, like Jan is where my petition currently ends. So I'm kind of really in a very stressful situation right now, trying to evaluate different options and alternatives.
Yeah, it's an unfortunate situation, and it's aggravating that you're in that. But unfortunately, there's just not a lot of great options.
Got it. Okay, cool. Thanks, John.
Hema Kanuru? You are on mute.
John, actually, hi, John. Good morning to you. Ashok, good morning. Hi. John, I am an employer, in fact. See, I got in one inquiry from like a different person from India a couple of days back. So is it right or wrong? Because in the LCA, the employer is paying hourly. It's not the salary based. The consulate, they interviewed that person almost like a couple of hours. They said that why your employer is paying hourly, it's supposed to be salary basis. So here the Department of Labor is already approved the LCA and the USCIS has approved the H1B, but the consulate people stopped that person.
Oh wow, that's embarrassing for them. Because the Department of Labor regulations are very explicit on this, that you can file the wage based on an hour. and you're required to, if it's a full-time position, to employ them for a minimum of 35 hours a week. So I can't imagine, other than lack of training and lack of knowledge regarding the law, I can't imagine why they're asking that.
Yes, John. Yeah, that I think what I
Yeah.
guess that is not able to answer like 2020 hours, which is mentioned I-129. But however,
Yeah.
it's the end of the day, employee is screwed up. That's employee is screwed up at the India. That's the reason I'm asking. Is there any way we can fight for?
Yeah, so it's the same. It's a different type of argument. Like I said, there's the random cases that don't fit the three main models, but that's one where really it would lend itself to an individual lawsuit, not a group case. And you just have to really go through those facts with the court. I think once you lay out the facts and the law, the way this works is the U.S. Attorney's Office gets the complaint first. They review the complaint, then they talk to the government agency. If they review the complaint and think, what the heck are they doing? This is stupid. Why is the State Department doing this? Then the conversation they have with the State Department is going to be, you need to fix this. So in a situation like that where they're completely misunderstanding the law and it's really not even up for debate, I think that's the type of conversation the U.S. Attorney's Office is going to have with them.
Okay.
Santosh? Santosh.
Hello.
Yeah.
Yes. Yeah. Hi. My name is Santosh. I have a quick question. I work for a non-profit university. I was an international student, and then moved to H1B with the non-profit H1B, and I worked for almost this is my 6th year. So in the meantime, what I did was I just wanted to get out of the non-profit and come to profit. So this year, I went through a lottery process with a consular consular visa process, and my H1B is approved with I-797B. So at the same time, it's approved right now, but I'm still waiting with my current employer for my I-140 to get approved. And the new H1B that got approved starts from October 1st with a valid visa, of course. But if I do not move to the new company where my H1B got approved, do I need to still go through a lottery process again, or am I good for the lottery forever?
So you would need to enter into the U.S. on the H-1B visa.
I'm currently in the United States.
Oh, so yeah. I would say you would be safer to go to work for that new employer and then switch jobs.
Oh, if not, then every year, I have no plans now to move out because of my I-140 being processed. So, and of course, this the new H1B with the lottery one is approved for 3 years. So just thinking once my I-140 is cleared, then I wanted to move out. Until then, I just want to stay with the company. So just wanted to make sure.
That's really not a State Department issue, but if you want to talk about that individually, I can set up a time to walk you through it.
Sure. Thank you so much. Not a problem. Okay.
So, anyone else? We'll take a last question and then we'll summarize and wrap up the call. So we can take one last question if anyone have. If not, okay. I think we'll give a chance for other people to. Okay, I know you had asked other questions. So if no one is there, then definitely you'll get a chance. Anyone have any question or? Okay, Vishal.
Thank you, Tana, for giving this opportunity. Hi, John. So I have a question on. So I have given 221. I have already asked my question, but I just want to repeat it again. I have given a 221G, that is white slip, and they have check marked on administrative processing. They are not asking any documentation. So will my employer is able to give all the documents which I have submitted again and submit to the consulate to expedite my visa process?
So my phone cut out on me for a second there. So can you, I'm sorry, but can you restate that question?
Yeah, sure. So I have given a 221G, that is white slip, and they have check mark on administrative processing. Usually they will be having like 4 or 5 options. They will, if the visa officer is not clear, they will be checking mark on extra documentation, but they did not ask anything. Just they have check mark on the administrative processing. So
Got it. So the law is pretty clear on that they're required to explain why and what documents you need to provide in order to get over. And when they haven't done that, I think that's a violation of law. And under the Administrative Procedure Act, anytime a government agency doesn't follow its own rules, the court will make them follow the rules. And so situations like that, the court will make them tell you what is required to adjudicate the visa.
Okay.
Yes, hi.
Hey, hi.
Hey, I just have one quick question. Like I'm in the same thing wherein I was given 221G yellow slip and I'm still back in India. It's been like more than 4 months that I'm in admin processing. They did not ask me for any information. Even my employer tried to email DOS, but there's like no update. Do you think any action that I can take or my employer to expedite the process?
So there's really nothing administratively you can do in terms of dealing directly with the agency. Everybody has tried just about everything they can think of amongst immigration lawyers, and the State Department is just really hard to reach. The only real thing you can do to try and get and create some certainty is through the federal court system. So filing a lawsuit in your case, just saying, hey, the State Department violated the law, then, you know, I think those are cases they almost have to settle. And I think they're strong cases. So outside of a lawsuit in your situation, I really can't think of anything else you could do.
Okay. So, Sudhir, you have any question?
Yeah, I have one question. Thank you. Hi, John. My name is Sudhir. I have one quick question. I was in the US for 3 years, from 2017 to 2019. I came back at the end of 2019, and I found a new employer last year. And I applied, and then my H-1B was approved, but I went to visa in June this year. And I was given 221G white slip. And until now, I did not get any response. I mean, they did not send any email asking for any details. Is that normal? I mean, I have friends who got 221G, but they all have received response from the visa officer asking for documentation. But in my case, they did not ask me anything yet.
Mm-hmm. So is it normal now? It happens, you know, you're about the 6th or 7th person on the call that is in that exact same scenario where they get a 221G notice and there's nothing on it. There's no requested documents, nothing that you can do to help them make a decision. It's not supposed to be that way. Under the law, they're required to give you that explanation so that you can address it, and they're just not doing it. And so that's why I think those cases are so strong in court, is that once you sue them, it's a pretty clear violation of law. The judge is going to make them comply with law.
So attorney, I know it's been an hour. So in the wrap up, so you are ready to take up the case if any one of the petitioners come forward, and there is a high chance that we are going to see a positive response from the state. And also, I think we need the people who are really suffering to come forward and be part of this case, if anything we are going to do, so that we are going to be we are actually going to change the practices that the state is following. Am I correct, attorney?
Yes, that's exactly right.
Okay. So you want to give your wrap-up statement, or?
Sure, thank you. It was great being with y'all this morning, and it was definitely worth waking up for in the middle of the night to talk with you. The one thing that I would say is, starting back in 2018, when I started in private practice, 2017, 2018, one of the first cases I took was challenging the DHS because they had updated the rules on their website regarding OPT, and they prohibited third-party placement from using OPT. We sued. 2 weeks later, they changed policy and they changed their website. They got rid of that rule and was pretty smooth. We've sued on a whole bunch of other cases where the government has violated their own regs or is misinterpreting the statute. So it's good success. So you can fix your problems through litigation in court, and you can get a positive result when you push back against them and make them follow the rules.
Okay. So thank you, Attorney John, and thank you everyone for joining the call. And like John is in Germany, and the time is around like 4 in the morning. Thank you for your time, John. If you have any questions, I sent John's email in the chat. Feel free to directly interact with the John, and I'm hoping that you all will be part of this great change that we are going to put forward. And I know like the genuine people who are really the true employees are being suffered. So I wish you all a good luck. And if you have any questions, please feel free to join directly, or you can also send me an email, treasure@tana.org, treasure@tana.org. Thank you once again, and have a good night, good day.
not clear, they will be checking mark on
Phone call?
Dilip.
Hi there. Ashok?
Hey, John, give me 1 minute, John, okay?
Yeah.
All right, sounds good.
చెప్పండి అన్న.
నేను co-host చేస్తున్నాను. ఒకసారి అందరిని అడ్మిట్ చేయవా?
Okay. సరే.
John, let me try to see settings, if there are any settings for you to join from Germany, okay? Give me 1 minute, okay?
Sounds good.